I wanted to run through a couple of the things that we plan to do at the General Assembly this year. Don mentioned that we're going to be looking at the warranty statute and need some help from you and your techs. We've done some meetings with some fixed ops folks around the state to really drill down into some of the warranty struggles that you all have. One thing that surprised me is how bureaucratic their processes for filing this stuff is. Writing stories about rental car. I mean, anyway, that's I feel for you more than I did before. But so what we're going to do with the warranty statute is make a couple of changes that we think are critically important and will help some of the pain points that we identified. First, our code says that you get paid your retail amount. You figure that out by the 100 repair orders, and that's presumed to be reasonable because you've gone through 100 repair orders, unless the manufacturer can show that it's not reasonable. Well, the problem is the manufacturer just goes, oh, well, Joe Schmo down the block is cheaper, so you're not reasonable. Well, that's not appropriate. There are a number of states that have just removed the term reasonable from their statute. That's what we're going to attempt to do, is to say, if you determine it by 100 repair orders, that's what you get paid. They don't get to dicker about the amount at that point. That's how the statute establishes it. That's how it works. Sounds like a relatively simple change. This is going to be a tough one because they really like that word reasonable, because they know that if they come back to you and say, you're not reasonable because somebody else is cheaper, so we're only going to pay you this, that the chances of every dealer fighting them on it is not good. So they know that they can always sort of poke a hole in that part of the statute. So we're going to attempt to seal that up and make it a little easier for you in the proof part. Secondly, we're looking at what we're calling parts pricing manipulation. As soon as they announce some sort of recall or bulletin or whatever, one of the things that we've seen them do over time, many manufacturers, is just wholesale reduce the price of that part, so it slashes your markup that you're getting on all those repairs just overnight. And so what this bill would say that the price of the part has to be the highest price of the last 12 months. And that just keeps them from manipulating those parts pricing when they're doing a recall, or we're calling it a recall-like repair, because a lot of these don't get to the point of being a recall. And that certainly is something that we think will help. Another moving part of this bill is making clear that you get full payment for diagnostic time. The code already says that you are to be paid your retail amounts for diagnostic, recall, and warranty work. This bill would simply say that includes all the time you're waiting online. That includes all the time you're waiting to hear back from the manufacturers. It's not just a simple matter of, oh, well, while I'm waiting for this repair, I'll just move on to the next car to repair. I mean, that's just not what we're hearing as to how it works. So we're going to make it clear that there has to be a process, and this is going to be a tough one, because how do you do that? But certainly wanted to include it in the bill, if for no other reason than have it as a shot across the bow for these manufacturers, to make sure that we're looking at that and raising that issue with legislators, because we're starting to hear that some of the service managers and the techs that we've talked to have said they feel like they're troubleshooting these new cars for these manufacturers. I know Barrie told a story of having a manufacturer say, well, we want the tech to drive it for 1,000 miles before we'll authorize the warranty repair, to try to figure out what's going on with it. I'm like, are you going to pay the guy to drive the car for 1,000? I mean, that's insane. So it's getting to be a bigger and bigger problem as especially with the newer technologies. All of us, and it's resonating with legislators too. All of us have had the unfortunate experience of waiting on a helpline for our computer or our phone or whatever. They get the frustration and the idea that a tech's just doing that and not getting paid, or that the dealer is having to make up that payment is something that legislators understand. That's how we're framing a lot of this. It's really a matter of the techs being penalized for not getting paid for the time, or the dealer having to supplement. And let's be clear about what all this is. This is all about product quality, right? So it's the manufacturer pushing down the costs of improving their product quality through these repairs onto the dealers, and that's just not something that they should be allowed to do. So again, that's going to require them to make sure that they're fully compensating for diagnostic time. And then the last thing in the warranty statute is the payment time for rental reimbursement. We put in code a number of years ago that if a manufacturer requires you to provide a rental vehicle for a customer, they have to fully compensate you for that. We know they are not doing that. We know they have their standard rates, and you're eating a portion of that all the time. Don't know quite how to address that, except to say that, at some point somebody's going to have to raise their hand and say, we're not doing, you can't do that to me. I don't know how else to put it in statute and clearer. But one of the other things we're seeing is long delays in these repairs. You may have people in rental cars for lengths of time that you never would have anticipated, 4 or 5 years ago. And so the problem becomes you're not getting paid for that. You're not getting reimbursed for those rental charges until you complete the repair and submit the warranty claim. Well, what if that's 6 months or 9 months from now? You're floating tens of thousands of dollars of rental amounts for the manufacturer until they can get you the part and you can get the repair done. So what we've said is there's got to be a mechanism for you to be recovering those costs as you're incurring them. We've said 30 days after you've incurred them, they need to put in a process to pay. They're going to whine because it'll be a challenge of that's not how they process warranty claims now. They can figure it out. It's just we think this is an important issue and something that will just help the dealers and your cash flow, and not incurring those expenses for long periods of time for the manufacturers. If a manufacturer says, well, we don't have people in rental cars for that long, well, then you shouldn't worry about the bill. You should be fine with it. They won't be. And then the last change that we are proposing for the 2025 General Assembly has to do with your buyer's orders. We've been working with Reynolds over the last, it's been 2 years, hasn't it?
My dad was alive.
Yeah, yeah. To revise the buyer's orders. So for so long, we were constrained by the size of a piece of paper, right? Because we're still working on paper. We're past that now. So most people are using some manner of electronic documents. You may even be providing those documents to your customer on a thumb drive or by, encrypted email or however. So we're no longer constrained by sort of the 8.5 by 11 piece of paper. So the documents will be very different from what you're used to seeing, but it's going to give you a lot more space. We're working with Reynolds to make sure we have a long enough runway, because it's going to involve reprogramming and some significant changes. But one of the things that we're doing, we are the only state that hasn't gone this route yet, is we are creating a buyer's order for leases. The terminology in the buyer's order doesn't really match, a lease transaction. So we're going to create a separate document that you can use for leases. And when I say it is permissive. We're not putting a drop dead date, so we were concerned that a dealer, may not get the message and is using the wrong form, and we didn't want to create any sort of, liability for you all. But we're going to be recommending those through Reynolds, and it just changes the statute so that the terms, instead of saying purchaser, it can say lessee. Instead of saying, down payment, it could say acquisition cost. So it's tracking the language a bit more, and then it's also taking that spot delivery language we have on our buyer's order that refers to sales and putting that in for leases. I don't know that there's many times that you're really spot delivering on a lease, but it could happen. And if you got to get the car back, you got to have a mechanism. So it'll cover all of that and just, again, be a much more seamless process. We are working with Reynolds on some training, but this will be something that gets rolled out here, maybe even by the end of the year, first of the year, certainly.
Yeah, they want to roll them out as quick as possible. They will look significantly different, and there's some boxes to check for which I think they told me I was one of the top 10 worst that they've ever dealt with, and top 3 most negotiated forms. So I was
her dad would be proud.
I was very proud of myself. The truth of the matter is, one of the things that bothers me about forms is, I review forms all the time for dealers. Boxes are missed. Signatures are missed on certain things. So I was like, please tell me that you can't get past this box to another section when you click it. I mean, everyone uses a different DMS, but it's pretty clear where they go, I think, but we are going to have training. So we're going to do a webinar that really breaks it down so that you can just play our video for in the stores. Because, but there's also significant protections for you on the back that you may have, over the years, people have made their own forms because someone's come in from somewhere, they like this language, that language. It really is a better form. It's just we need to make sure that everyone is checking the correct boxes and, everything is not going to be missed on the form.
Yeah, and so this legislative change will just allow. Reynolds was reluctant to go forward with our spot delivery language, quite frankly, without it being in the code. So we're just going to make that change and make it a simple.
And Tanner, we'll get to you 1 second. Just make one comment. If the CARS rule goes through, and that's a really big if right now, one of the things is it has to be clear if it's a purchase versus a lease. And so this makes it easier to be in compliance with the CARS rule, because on our buyer's order, we've never, I think I've litigated several dealer cases over the years. I've never had one that said, hey, I don't know this is a lease, because obviously they're signing a lease contract, right? But to be in compliant with the CARS rule, it just makes it easier for you all with the new buyer's order. Tanner.
So we've got a limited number of DMSs, and we have existing dealer cap forms for this. So CDK has a lease purchase order that dictates the terms. I wonder whether or not it would be advisable to grab those dealer cap forms, automate this and that, and find out what the language is going to change on the Reynolds and make sure it's transposed onto those.
Well, it's.
You follow me? So Reynolds has their proprietary form.
Yeah,
Right.
we can certainly work on that.
Yeah.
What is updated from the current Reynolds?
Sure.
To make sure that CDK and Automate.
Sure.
And they'll all do that. I mean, they'll all, once
Yeah.
it rolls out, this is just, we needed to have in the statute, what this goes back to, right now how the spot delivery language reads, it is more towards a purchase. The problem you have is right now on the standard buyer's order for Virginia, it said this applies to leases as well. It's right above the spot delivery language. That spot delivery language is by code statute, so any other spot delivery form is irrelevant and actually messes up your spot delivery in Virginia. So you shouldn't be using any other contractor form for spot delivery. It's already in your buyer's order. But the problem is when it becomes a lease, technically it's part of the contract instead of it by statute. Right now we're going to put it in the statute so you have even better protections.
And with that, I'm going to turn it over to Mimi to make a couple of comments about the legislation and the help we'll need from you.
Yeah. So in the upcoming 2025 General Assembly session, the proposed changes to the warranty statute are going to be carried in the House and the Senate. In the Senate, the patron is Senator Jeremy McPike. In the House, the bill patron is Delegate Brianna Sewell. The buyer's order statute will be carried in the House only, and that'll be patroned by Delegate Jackie Glass. These are all these representatives are people that we're working with, that we've had discussions with, and they understand these bills and what they mean for you all. So in the meantime, before session starts, what you all can do to help is to contact the legislators. This is specifically important for dealers whose districts have legislators on the House or Senate Transportation Committees, so that you all can reach out to the legislators and help them understand how these changes would help you and your dealerships.
Yeah,
And we have a portal on our website that we'll have a pre-written letter, and it'll be easy. We'll send you all a link upcoming, and you all should be able to fill it out. And it'll take 2 minutes, 30 seconds. You can customize the form if you want to put a more personalized experience in there, and that will help the legislators understand how the issues are affecting their constituents. As Dawn and Ann mentioned earlier, we will have the VADA Dealer Day at the Capitol on Wednesday, January 29th, 2025. We are encouraging you all to show up and have your technicians show up to support the bills. I understand that VADA has done this in the past. It'll be my first one as well. But I understand that will include a lunch, a briefing. We'll visit the offices together. We'll split you all up into smaller groups. It'll be about from noon to 5, so it won't take up your whole day. We'll all meet at the Hilton downtown, and we will walk you through and we'll lead you around to meet the legislators.
All right, thank you, Mimi. And with that, we've sort of finished the General Assembly preview and want to roll into some of the meat of our presentation today because we've got a lot of issues to get through. So with that, we're going to roll into some federal and state enforcement. The FTC has been very, very active over the last number of years. You've been seeing these slides and hearing this from us, and we keep sounding like a broken record because we keep seeing the problems. So we're going to go over some of those today, from advertising and selling practices, equal credit, sale of add-ons, safeguards, credit reports, and the used car rule. Again, these are all things that we've talked about, but just want to make sure we're reviewing them and keeping everybody, keeping all these issues front of mind for everyone. Advertising. The FTC has taken enforcement action against a lot of dealerships for advertising. This is the way they get you, right? Because it's something they can easily see and find. They have been looking very closely at the way you all are showing prices on websites, and there's some things that we think as an industry we need to be aware of and really make some changes to sort of the way things have always been done. I'm not going to spend a lot of time on truth in lending and Consumer Leasing Act. You all know the trigger terms. You know how all that works. If you've got any questions about that, certainly, talk to us, or I can send you just a real good link to just the basics on that. But we keep bringing all of these consent orders to you because there's always a new one, right? So in August of this year, there was a consent order against a dealer group in Arizona. A couple of things that I would point out with this: the advertised prices did not include, market adjustments, add-ons, other miscellaneous fees, and that was a problem. I don't know that we're seeing it as much as we have been, but it's still very, very problematic as far as what you're disclosing as your price. And we're going to talk about that. Barry's going to talk about that in depth in a bit. But again, the findings here were that the dealer didn't include all the fees and the charges that were were not included in the advertised price, that they misrepresented that the add-ons were somehow required to be purchased. They charged more for add-ons to certain groups of people, Latinos in this case, and they paid $2.6 million to settle that case. So again, you got to ask yourself how many cars do you have to sell to make $2.6 million? And that's really what it comes down to.
I want to also mention, and I always tell dealers this, $2.6 million is a lot for a two-store dealership group, okay? Coulter was 2 stores, $2.6 million. They probably also spent almost $2 million in legal fees to get through the CID process and the FTC negotiations. So they're probably at almost $5 million, okay? But the payment is one time. They are under a consent order for the CARS rule. The FTC will not enter into any consent rule without the CARS rule added by contract for that dealer. They are completely handicapped when it comes to advertising, pricing, disclosures, and financing products, okay? So even if the CARS rule never goes into effect, they have a consent order for about, I think, 20 years that they have to adhere to the CARS rule. Every single advertisement they do, they have to keep. It is a disaster, okay? So the consent order is probably the worst part about all of it. And most of the times people do enter consent orders because they entered a $2.6 million settlement, and you're getting a consent order with the settlement, and that's going to require the CARS rule. But to fight it was probably about $6 million. Okay? So that's why people enter into settlements, and they do not like them, but it becomes a business decision. So instead of, when you're sitting there fighting with a consumer over $5,000, and you're like, okay, fine, I'll take, we're going to just settle the case for $5,000. You're settling this for 2.6 instead of 6 million to fight it. Okay? So that's why consent orders are terrible, and why the FTC actions have really taught a lot. So.
Again, we're not going to go through, spend a lot of time going through TILA with the credit, with the trigger terms. It's in there for your reference. Also, advertising, consumer lease, the same thing. You got to list all those amounts. We've all done this before, but it's always good to have a slide in there to remind us. Again, back to this, to advertising. It's a simple statement, but do not advertise a price you do not plan to honor. I think everybody around this room would be saying, oh, we would never do that. We all do it. It happens all the time. And part of the problem is that this is the third rail for the FTC, because they view it as a bait and switch. They view it as probably one of the most problematic practices that you can have. You can't use a disclaimer to get around some of these things that are not included or improperly excluded from your price. So again, a disclaimer does not solve your problem. A disclaimer basically cannot negate anything else that's in the ad. So you've still got to do the ad properly. Yeah, we're getting to the point where you're not really going to be able to show a net price at some level. And here's what I mean by that. If you are showing a price of a car, say it's MSRP, and you are listing a bunch of of potential savings underneath, netting out that price below is getting to be very problematic, because the things that you're listing above are not available. There's no person on the planet that can get all of those things. So the idea that you can just list a whole bunch of incentives or other things that might be available to groups of people and somehow create a net price at the bottom is going down a path that is very problematic for the FTC right now. And I know Barry's going to go through that in depth on actually the next slide.
Yeah. Okay, so when we're talking about incentives that are, I'm talking about the conditional ones, the first responders, the conquest ones, the first-time buyer ones. Those are now going to best practices, truly best practices, because Motor Vehicle Dealer Board used to have an ad that we used to show for the last, 10 years.
It had a Model T on it.
It was literally the oldest ad in the world. I couldn't take it anymore because FTC was getting dealers on what was in that ad, and now the Motor Vehicle Dealer Board is actually going towards how the FTC wants advertising. Okay, so how many GM dealers do we have in the? Okay, GM is making all their dealers have advertisements that look like this, and the truth of the matter is, it's because the FTC is hitting all the dealers for advertisements that don't look like this, and that is in the top. You have your MSRP, and if you're taking your incentives after, most dealers have some type of discount that they do. This isn't the pandemic, so you got some type of discount. And a lot of times in Virginia, you're taking out the freight cost. Okay, some people are. That can come out of the discount because freight is allowed to be removed in the state of Virginia, and you are able to put it in your disclosure. Okay, but the exact amount of freight has to be in the disclosure. Okay, so you also have your bonus cash. Your bonus cash is available to everyone. Your customer cash. I don't like GM's customer cash disclosure. We've talked to corporate. It is terrible, but they're pushing it to the websites, as I understand it. So it is what it is. But it is available to everyone. What happens is you then have my dealer price is X. Okay, that's the price that's going to be on your third parties, because it literally doesn't have. You're doing it through VADA, and it's pushing to all the third parties. Third parties should have that exact amount across the board. If you got 30,000 on one third party, you got 28,000 on another, you have incentives included in your website, what is the price of the vehicle? And the FTC is literally getting the advertisements from third parties, okay? So if they want to prove something against you, they've got all your advertisements from third parties because you haven't kept any of them, and your provider doesn't have any website advertising, okay? So what happens is your third-party advertisement that was never updated with the current pricing because it wasn't through VADA, or if you added some incentive in there that then went away, what happens is they do that and they look at the deal file and the pricing doesn't match up, okay? So that's why I'm mentioning it. When then you do the additional incentives. Take Tesla for example. It's a complete violation of advertising because they add that $7,500 to off the price of the car. It is a violation under Motor Vehicle Dealer Board. In July, they got several fines for it. What we're trying to do by this advertisement is show you completely compliance federally and Motor Vehicle Dealer Board, okay? So all the conditional incentives should be available for someone to do the math, but technically shouldn't be in your ultimate price, okay? Because most people cannot meet, the human unicorn of the first responder or military, who's also a first-time car buyer and had the disaster assistance, was in the middle of a hurricane in North Carolina, is not meeting all the incentives for which you've already taken out of the price, okay? So that's the truth of the matter. And people are getting hit hard, okay? And then with your disclaimers, your disclosures and disclaimers are used to explain those terms for why you have them. So your dealer discount, available to everyone. Your bonus cash, available to everyone. Your customer cash, not available for some financing offers. That bothers me so bad because then you'll have your financing tool on the side that will show whoever's, I'm taking GM again because GM will have some special financing on the side and that won't match with the customer cash, but the disclosure will say not financing, can't use with special offers. So they either take the customer cash or they're taking the special financing. I mean, that's literally what's going on. But needless to say, all that should be in your disclaimer explaining to people how they're either meeting the additional, your freight, well, I'll get to freight in a minute, but your freight should be down there. And of course, your processing fee in Virginia has to be on your website. As of right now, your processing fee does not need to be in your price. And I say as of right now because things may change federally and in Virginia for that, okay? So these are just some notes. I've kind of walked through the compliant ad, but this is explaining what I did on the compliant ad. That's a fake ad. I am not an advertising major. I'm just, but the big one is really the freight. So if you've removed freight, how many dealers in here remove freight from their price? None? Oh, wow. Okay, well, if you ever do remove your freight, okay, some CDGR dealers a lot of time remove freight. For the longest, I was told freight's not included. Well, it's included on the MSRP. So what happens is if you remove freight, the freight's $1,500 out of the advertised price, okay? You remove it and you put it as a dealer discount. You gotta put the exact amount of that vehicle in the disclosure. Well, everyone's sitting there going, well, the freight changes all the time by the model or whatever else or the year. So I've told dealers, you put a link to the freight costs so you're only changing that freight page, or that link freight page has it has 2023, 2024, 2025, every single freight listed, so the person can go and find whatever model it is and you can actually find the exact freight amount. But you have to have the exact freight. It can't be a range of $1,000 to $2,000. That's not telling the person what the freight is. They need to have the exact amount. If it's $1,395, it needs to be linked and it needs to be available for them to do the math themselves. If you are charging MSRP on a dealer that has already removed, for the most part, you remove freight. Well, MSRP already has freight in it, so you're not double freighting. So on the pencil, it shouldn't have MSRP that be the price of the car, and then the freight should not be included again. You're charging them double. Okay, so that's just some if you do remove freight. Geographic pricing, internet pricing, those are non-existent, okay? There's no such thing as an internet price. So if someone walks into a dealership and you have on their internet prices, the vehicle MSRP is 30, the internet price is 20, but they don't tell you that it's they saw it on the internet. It doesn't matter. There's no such thing. That $20,000 for which you're advertising, that is available to every single person that walks in. Geographic pricing. Some people you don't get your incentives on the back end for selling outside your PMA. No such thing. Every single person gets that price. So if you take in the dealer discount, some type of incentive out, and you get dinged for it you're not going to get it. Doesn't matter. That dealer discounted price still needs to be the price. There is no such thing as a geographic price, an internet price, nothing. Every single person gets the price of the vehicle.
Can I ask a question on that? So some manufacturers have regionalized incentives, right, by business centers, et cetera. So what you're saying is if we're using the price where, the dealer thinks, well, everyone gets it in our 5-state radius. But let's say like the Northeast region has a lesser rebate. So if someone drives from New York in my dealership, best practice is I honor the lower price, even though their regional incentive, because it's by their zip code where they reside and title registered.
Absolutely.
I have to honor the lower price.
Yeah, if you've advertised it at that price, you gotta honor it. You gotta honor it.
I have a question on that. So Chevrolet right now is doing select market bonus cash on multiple different models. And it's one of those rebates that's always above the line. It does not go into additional discounts because that's how Chevrolet wants it. That's how they push it. So if I have a customer that literally drives over from Fredericksburg, hypothetically, they do not qualify for that select market bonus cash.
But they've already pushed it to your advertised price, right?
Yes.
Yeah, you got to give it to them.
And, and again, if it's the manufacturer pushing that information to your website, which is what they're doing, that's, we need to be working on the manufacturers to stop doing that. And so that's where.
Since it's a rebate, it has to be listed as a rebate, right?
Is it your?
Oh, you mean in the advertisement?
Yeah.
But they're pushing it to your overall. They're pushing it above the line, so it comes out of your bottom line, right? Yeah. It has to be. But the truth of the matter is, it's one that they're going to have a disclosure that says available to everybody.
So again, Barry, for clarification, if it falls under additional offers, that covers this, right?
Yeah. So if it's under additional offers and it's not available to everybody, it's a condition for which they have to meet, and they don't meet the condition, it's not in your bottom line pricing. But the problem is you're talking about when they push that bonus cash and customer cash to that above line, above your dealer's price, you're going to have to give it. Literally, I think the disclosure says available to everyone.
The select market bonus cash, it does say you have to be living in a certain zip code. But again, it doesn't change the fact that it's above the line.
It's above the line. That's yeah.
So I guess what I'm asking is this, that it has to be listed as a rebate because my sales price is never going to match on a bill of sale or a contract.
Exactly.
So then I'm in a violation for my manufacturers because if anybody's a big fan of connected incentives, which I'm sure nobody is, it's never going to pay your incentives out because you were applying for one thing, but you're not honoring one thing. So
Right. And the problem with that is they shouldn't have put it above the line if it is a zip code requirement. That's an incentive by zip code. And they shouldn't be putting it above the line. And they're going to make you in violation. That's the difference. They don't have to follow.
Well, and I will just say this. I mean, we will work on that with you.
Yes.
Because that's a manufacturer issue, and they need to understand that in this world, they would love for you to live in the little box they put you in your market area, and you're only sell to customers there. Well, when it suits them. You only sell to customers there, and nobody ever comes from outside of your box to buy in your box. So we'll work on that. We can work on that with the manufacturers, but just making dealers aware of it. The problem is you may be good with GM, but the FTC you're not going to be good with at some point, and that's where the no pun intended, the rubber will hit the road, and that's where the real danger lies right now.
Okay. Okay. Virginia is very specific what fees are allowed. Most states are. Basically, you can have your titles, tags, processing fee, and freight can come out of the advertisement. But those are the only fees. There's no reconditioning fee. There's no, Virginia does allow the transfer fee if advertised a certain way and everything else. And that isn't in the code. I mean, they've.
There's some dealer board administrative
decisions on it. But it's very, very, I mean, I think it's like 300, I think it was,
it's really not something that most of our dealers are doing, so.
Right. But the truth of the matter is, you don't be charging the reconditioning fee. Don't be charging fees. It is the easiest way because it's literally on the buyer's order. So when people are looking at your buyer's order and they see that, you will be in violation with the Motor Vehicle Dealer Board. You can do an Attorney General complaint, and then you're going to have a customer with some plaintiffs. I mean, there's literally a plaintiff's attorney in the state of Virginia that has given bar CLE classes on how to sue dealers, okay? So you have those in Virginia. As of right now, Virginia does not have class action suits for state actions. That will be coming in the next year or two. So for that reason, do not be charging a fee that you cannot, that is not permissible, because you will have a huge class action in the state of Virginia if you do not have arbitration that gets you out of it. This was recently in the Motor Vehicle Dealer Board newsletter. Those are actually great newsletters. Okay, so this was in the newsletter recently, and it went on about advertising, and they basically said that get your advertisements right, and if you've had it, if you can show, if the dealer can show that the manager or the salesperson that is advertising improperly has had training on it, or if someone can show it, that manager will now be fined. That salesperson will now be fined. Well, that's also the licensing board for, so when you don't want to have a license suspended or revoked or anything for repeated advertising violations, okay? So my point being is they gave a deadline, kind of past it, to get your advertising right before they actually start dinging dealers for improper advertisements. And the easiest way to get dinged is when your competitor sees that you're really doing a bad advertisement and it anonymously shows up before the board, because that happens quite a lot. I think that's how Tesla got in trouble. It was so that, so the truth of the matter is they are now looking at that, and they will start finding people in the dealership. And they know it. I mean, your salespeople are all licensed, all on the board website. I mean, and those $1,000 fines start adding up very quickly. And these are the dealer advertising requirements. So these were the most common. In here, the letter was supposed to be linked on the newsletter for the Motor Vehicle Dealer Board, for which it wasn't. So I wrote the Motor Vehicle, Ann sent it to me. This is the letter that was supposed to be linked to it. One of the biggest things is not having a phone number on the advertisement for someone to call the dealership instead of having to go there. The reason why I'm pointing this out is who uses TrueCar, Car Gurus, Cars.com, all the third parties? Probably every single person in this room. A lot of times, those third-party sites do not have your phone number. They have a 1-800 number so someone can call there to get the lead, okay? Technically, that is a violation in the state of Virginia, okay? And I'm bringing that up because the third-party vendors are what is going to get you in trouble. So,
so you're saying that an 800 number on a third-party site that links directly to your local number is in violation because it's not your local number?
No.
Okay.
No.
If it's linking to your local number.
If I dial it and I get your dealership.
Well, I shouldn't say that. The number has to be registered with them.
No, we clarified that with the dealer board at the last meeting. Yeah.
Okay.
Because that's an easily provable thing, right? The dealer board can pick up the phone, call the number. It's where that number does not go to the dealership. Yes, there was some back and forth. The dealer board staff was wanting to take the position that it was a registered number. And we told them that just doesn't work technology-wise. So if I can, and again, it's easily provable to the board enforcement staff, right? Pick up the phone. This is
But if it's
Witten
not
Brothers.
going to you and it is going to some other service, you got to make sure your phone number's in the disclaimer on the third party.
Yeah.
Okay?
And again, the third-party sites are, yeah.
So because Car Gurus is the culprit, so they've got a screen between the email and a screen between the phone. So it's not a redirection so it rings my phone at the store. It actually, you're not emailing the customer. You don't get the customer. It goes back to Car Gurus and then from Car Gurus to the customer. So it's like they're a mediator. They're like almost screening.
Because they want the lead.
Right, but the dealer, there's a rule in Virginia that any number listed on the ad has to be the number for the dealership. So if they are answering that phone as Car Gurus, or are they answering it as Page Auto Group?
Yeah. That's
Yeah.
what matters.
And so it doesn't matter, you can outsource your phone stuff. It's just how is that person identified on the other end of the line?
Okay. And
again, we backed the dealer board off of having to register. I mean, I can't imagine the dozens, if not more, phone numbers you'd have to register with the dealer board just to cover all the third-party sites you may be using.
okay. And the third parties, again, I've gone over them, but they are becoming an issue. If your pricing is not the same, if you don't have the same disclaimers, it becomes a problem. And a lot of times, when you're changing pricing constantly, used cars, if it's not being updated on those third-party sites, you have a different price. And you don't know what people are looking at. If they are looking at those, and when I say people, I mean actual, regulators, okay? You don't know what they're going to match up to say you did not sell at the advertised price, okay? So you need to make sure, yeah.
So speaking to that very same impact, the regulators, these wonderful humans that are going out there and scouring and looking, so there's a different time that it pushes through to different various sites. There's going to be a time delay.
There is a time delay, and there's
platform of each of these third parties uses. Common decency and common sense that they don't have their government.
okay. There's a defense, and then there's, for the most part, you're not going to have one advertisement that gets you in trouble. Okay,
That's very repetitive.
it's going to be a repetitive thing. Okay. And then what they're going to do is they're going to subpoena 3 years of your advertisements on these sites. If they cannot see that at some point you're not updating them, or I think one of the, which one sends you the note that says change the price to move it back up to the line? Which one do you have to, is it Car Gurus that you drop it, then it moves it back up, and when you're playing with the pricing like that, that's what they're looking for. And that you're not changing it back to what the price is actually, okay? And we're talking thousands of dollars of difference. I mean, you drop a price on Car Gurus $20,000, but on your website it's $10,000. I mean, they're looking at big stuff. We're not talking about the time delay and things like that. That's a defense, and they're going to see that's not a repeated defrauding of a consumer. They're trying to find actual fraud for which it sits there for a couple days. They walk into the dealership and they said, I want this price. And you're like, no, it's, you don't meet, we put the price, that price includes all these incentives. You don't meet any of those incentives.
Thanks. Absolutely the case. I'll just emphasize again, the dealer processing fee and your online systems filing fee are the only two fees that are allowed by law. There is no points for creativity when it comes to these fees, and it's just the enforcement atmosphere is just getting worse and worse for dealers. So again, $6 million to deal with the FTC, you have to charge a lot of $250 fees to pay for that.
Okay. This just goes into FTC did a endorsement advertising rule. Basically, if you do reviews and you're paying for your reviews, you need to tell people that the review is paid for, things of that nature. Don't make up fake reviews. That's the bottom line. Actual true reviews. Okay, credit policies. you got to have, most of your lenders now ask for your credit policy, okay, your fair credit policy. You got to have one. NADAs is the best. I always recommend it. Adapt it for you. It is truly the best. And on the next slide is an exhibit to that policy. It is why you're deviating from the typical rate, okay? I've recently learned that there is a certain ethnic group that does not want to pay interest on vehicles, and so they're telling people, raise the price of the car. You don't raise the price of the car. You have them buy down the rate, and you put on this form, refuse rate different because they bought down the rate. They don't want an interest. That's it. I mean, there's no reason for it. Anyone can buy down a rate. So, but that's why you have this form for certain situations. Why there is a deviation. This form, for non-discriminatory reasons, keeps you out of trouble. So, VPPs is the same thing, okay? You should not be pricing, you should have a range. If there's any deviation, the VPP policy has the same thing as the fair lending, okay? Prices should be consistent, and there should be any deviation for non-discriminatory reasons, okay? NADA's policy on VPPs. The add-ons and VPP, can we just go back one slide?
Yeah.
Common theme in FTC regulations is the fact that people walk in and say, oh, I had to buy this add-on to get this price. They told me I had to buy this product, or I had to finance with them to get this price. Anything while selling an add-on that is a misrepresentation of how they get that price is defrauding the consumer, okay? So we always tell everyone, use a menu, let it be choice. But in the room, they should never have to use financing to get the price. The price was the advertised price, okay? It isn't you want to sell them financing, and if they want, if they want to pay for the car and they need it, that's what you're there for. But it's never linked together. They do not need to buy a product for to get the price, and they don't need the financing. If you are adding something to the vehicle, such as a trailer hitch or a bed, something in the bed or mats or something, you got to put it in the advertised price if it's already on the vehicle. If you do some type of etching or something like that, that's got to be in the advertised price. They can't walk into the box after and say, oh, that's already on the vehicle, you have to buy it. No, they need to know that when it's advertised, if it's already there, and then the rest of the stuff is all voluntary, okay? And if they choose to buy it, should have a menu, make the choice, and it should be all documented that they wanted those voluntary products. Cancellation, we always put this in here, make sure everyone's getting their refunds for cancellations. They have a right to it, it's in their contract. If the banks are giving you a hard, make sure the banks are actually giving you the correct amount. Kind of going through CARS rule. Okay, everyone knows that the CARS rule currently is on a stay. The hearing before the Fifth Circuit was not great. Mixed reviews. So they don't know what the Fifth Circuit's going to do. The Fifth Circuit panel deciding if the CARS rule will be enacted is made up of 2 conservative judges and 1 liberal judge. They didn't think it went as good as they thought. Now, with that being said, you have a new administration coming in for which is basically saying it's going to gut all the regulations. It's not as easy as just walking in and saying, we're not going to, it's already been passed by the FTC. It already had an enactment date, and the enactment date was already stayed, okay? So there's a lot of finagling that would have to be done if it does not get knocked down by the Fifth Circuit, okay? So that's kind of in a stay right now. The CARS rule will change a lot for dealers. Your processing fee would have to be in the price. Everything would have to be in the price of the vehicle. You're keeping every single advertisement you will ever do for the vehicle. The amount of paper is insane. The amount of disclosures that is required under it is insane. people have been getting ready for it. Comply Auto with NADA has come out with a Cars Rule book. As of right now, it truly is in a stay. We don't know what is going to happen. If the FTC also wanted to pass, if the Cars Rule got knocked out, they had a backup rule called the junk fees rule. Junk fees rule also has not been proposed. Well, it's been it's not been enacted like the Cars Rule. Junk fees rule was any fee, the Ticketmaster, all those fees had to be in the price. So it would cover car dealers in the event Cars Rule was not going to go into effect. So junk fees rule will come into play if the Car Rule is gone. With the Trump administration, that also is in a hold. Right now, the FTC is made up of 3 Democrats, 2 Republicans. One of the Republicans is a gentleman named Andrew Ferguson. He used to be the assistant AG in Virginia. He writes a dissent for he calls it concurring, but it's basically a dissent for most of the cases that get before the commissioners. To get a case, the commissioners basically rule on it before. Okay. Anyways, he basically said the Biden-Harris administration rulemaking is over last week. Okay. So with the Cars Rule, we don't know what's going to happen, but as of right now, it is going to be enacted at some point unless the Fifth Circuit does something wrong or it takes it away.
Again, just a reminder about accessing credit reports and making sure that you only access them when they're authorized. The easiest way to prove that it's authorized is to have somebody actually consent to it. I'm going to skip through this other Cars Rule slide. Safeguards rule, we've been talking about this for a while. Everyone should be in compliance. I know, we've endorsed Comply Auto to help with this. It's almost gotten to the point that it's very difficult for a dealer to do all of it themselves. So outsourcing some of this certainly shows that you're serious about complying and are undertaking those obligations very seriously. Again, written program, you got to have specific requirements. I'm not going to spend a lot of time going through all this because we've been talking ad nauseum, but just want to make sure that we're all paying attention. I call them the 25-hour-a-day, 8-day-a-week things. You would do them all if you had 25 hours in a day and 8 days in a week. So just, again, making sure you're doing all of these things. And this is where, a third party can really help with some of that monitoring and the ongoing testing and stuff that you have to do. Data breach requirement under the safeguards rule. Obviously, we all became, unfortunately, a bit more familiar with data breaches with CDK earlier this summer. As you know, those CDK dealers in the room, CDK actually filed the data breach notice with the FTC for those dealers. So there is a requirement under the safeguards rule for the disclosures of the data breaches as is outlined here. Virginia also has a data breach statute. It has 2 parts of it that are worth noting. First of all, it only applies to unencrypted and unredacted data. So if your data is encrypted, the data breach statute in Virginia doesn't apply to that data. And then it also provides an exemption for any entity that's complying with a federal safeguards rule data breach policy. So not too much to worry about on the state level in Virginia for dealers, but the moral of that story is encrypted data is all the more important in this day and age. Used car rule compliance, we always point this out. Buyer's guides, we still see, if you can believe, old buyer's guides floating around out there after all this time. You would think that somebody's stock would have run out by now, but just always good to touch base and make sure you're using the right form, that people are checking the boxes the right way, because they are so very counterintuitive and backwards in my humble opinion. With the what is a dealer warranty and what isn't on that, and then making sure also that remembering that the buyer's guide under Virginia law needs to be signed by the buyer as part of that deal. And then the other piece that we see the most often is that you've got to make sure you have that separate warranty document. The buyer's guide is not the warranty. You've got to have a separate warranty, limited warranty document. We've got a sample I can provide anybody that needs one, but it's not enough just to have a buyer's guide that says we cover X, Y, and Z for X number of days. So just pointing out those high points that we always try to cover.
We can literally skip this over. Yesterday, a decision came out. The Corporate Transparency Act, you do not need to file the beneficial ownership anymore. Texas is saving small businesses from the regulators on its own. Now they've done it with non-competes. They've now done it with the Corporate Transparency Act. So that's gone. And it really didn't apply to dealerships. It applied to the real estate companies, like your holding companies for real estate, and management, because there's an exemption for $5 million in gross sales and 20 employees. So dealerships really weren't covered, but I was very worried about everyone filing for the real estate companies. That's now, don't need to do it.
Yeah, just keep your ear open in case something changes on that front. But right now we're in better shape than we were when we made this presentation. And with that announcement late yesterday, we're going to run through some franchise issues very quickly. I know we're getting close on time here. Talk a little bit about EVs. You know, we've talked over the years about the conversation has now turned from how do I get these EVs to do I have to take all these EVs in a short number of years. So again, the manufacturers embraced this technology. We had legislation in 2023 that would have addressed, the agency model. There was some talk about direct selling in this arena. That's sort of gone a bit by the wayside, but you still have the ability to challenge any manufacturer who's doing the things that you do for a customer. So they can't just sidestep you and go into an agency. Again, this slide has been in this presentation for a while now. You're entitled to receive all of the models that your manufacturer makes. I know we're going to have a battle about VW Scout before too long. We'll see where that goes. But again, you are entitled to all makes and models. There was a time when you weren't getting those EVs, and we had a lot of dealers that wanted them. Had to add another slide, though, this year that says, you are also entitled to reject vehicles you don't want. So now you may have a lot of EVs sitting on your lot that you're not selling. You've got a lot of manufacturers who, at least till the end of the year, and maybe Toyota mistakenly further, as Tanner pointed out earlier, that want you to take a bunch of EVs because for the remaining, 3 weeks of the year, they still got to comply with those California requirements for model year 2025 vehicles in Virginia. So they may be pushing you to take inventory. Understand that EVs are not special. Just like you could reject any other inventory, you can reject those as well. Again, though, the OEMs are never going to comply with these laws. None of these are self-enforcing. So you can challenge their refusal to send you EVs, or you can challenge them sending you too many EVs. So just, again, keep that in mind. That's been a little bit of a change in atmosphere in the EV space that we hadn't seen up to this point. One other thing we'll point out with the EVs is there has been a bit of amnesty for at least a couple more days, if you will, to sort of catch up on some of those EV tax credit reports on the IRS portal. I know there was a lot of problems with it early on. We even had some dealers that didn't realize they had to register and couldn't do the sale reports. And so there is a little bit of a reprieve. Get your folks on it if you've got any of those credits that you need to fix from past deals. As we always point out, and more often than not, the calls I get, the dealers always do better when they know their rights. So understand what the factory is asking you to sign, understand what your rights are. Can they ask you to make the upgrades they're talking about? Evaluate all of those things by understanding what they're asking you to sign and understanding what your rights are.
Or what you're paying for.
Right, exactly.
There's some manufacturers that are pushing some costs onto the dealers, making a fee to
Subaru recently has a fee. We have a letter that'll go out shortly, some sort of technology fee for every technician they have. But it's not technicians you actually have. It's the technicians that they say you're supposed to have. So it's like a $69 monthly fee. So it may be that your service manager sort of said, oh, it's $69, no big deal. 69 times the number of techs you're supposed to have times 12 for the year comes real money at some point. So just be aware of all of the things you're being asked to sign and all of the things that affect your franchise that may go to somebody else in your dealership and not the dealer direct. That may have gone, for instance, to the service manager, not to the dealer. Couple of real quick issues. Over-the-air upgrades, just a reminder that we have a provision in code that requires you to be compensated for any time that your service department has in helping a dealer, a customer that comes into your store having problems with an upgrade. So that's something important to remember. Facilities, you can't be required to redo something the manufacturer asked you to do within 10 years. It doesn't protect your whole facility if you did part of it, but it certainly gives you protection from having to, take up your 10 by 10 floor tiles and put in 12 by 12 floor tiles, which actually has happened in the past. A number of these issues become important when you're talking about buy sells as well. There's lots of moving parts in those kinds of transactions, but one of the complications can be the manufacturer trying to take that opportunity to make somebody build a new building or take a franchise out of an existing space. So just be aware that the franchisor is not permitted to hold up a buy sell for those sorts of issues.
And the other thing about the facility upgrade, just one key point is, if you updated your facility in 2019, you are entitled to that incentive money for whatever program they do for the next 10 years. So you should be getting your incentive money, okay? So Hyundai was a big violator of this, but you should also fight for your incentive money. You're not only protected from having to redo the tiles, you're also protected in getting your monies.
And again, if it's an incentive program that has other moving parts, you still have to comply with those. But if it's a facilities incentive program, or if it's a facilities part of an incentive program, you're in compliance for those 10 years as well. They can't use that as a hammer. So again, you all are better at this as far as evaluating, what is the manufacturer threatening. They can't threaten to withhold incentives if you've done that facility upgrade within that 10 years. So make sure that you understand those rights as you're going through those incentive programs and any opportunities to upgrade your facilities. Again, we were one of the first with the 10-year rule, and you're deemed qualified for any of those incentive programs that turn on your facilities being compliant. Again, in buy sells, they cannot require a buyer to do something that they could not require the selling dealer to do. It gets a little complicated in how you enforce that statute, but it gives you leverage when you're having these conversations. We spend a lot of time talking about the nuances of these franchise laws and how they're supposed to work, but at the end of the day, the biggest thing it provides you is the ammunition to fight the fights that you want to fight. And so if we never have, and I may be dating myself, we never have that, the Perry Mason moment or the few good men moment in court over any of these statutes, but a dealer is able to work out what they need to work out with their manufacturer, that's where the strength of these laws are. So the more that you know them, the more you are able to use that leverage in the negotiations that you may have with your franchisor, and all of that is critically important. We are always a resource for you. If you are running into a roadblock, give me a call. There may be something that we can offer as far as information that'll help you navigate those testy relationships that you might have with your franchisor.
Okay, changes in ownership, any change, 1%, you got to tell the manufacturer. This is a big thing if the ownership is in a trust. If you own it and you want to move it to your trust for estate planning, the trust then has to fill out the application, has to be approved, okay? So any change in ownership, you want to give 5% to a manager, that person has to be approved, okay? It is a big deal. It is a violation of your dealer sales and service agreement. They will terminate you if you do not tell them, okay? Then you got to go through the termination process. That is also not fun. So any change in ownership, succession planning, anything like that, just tell them. You have protections in Virginia where they cannot say no to you, okay? They can't do a lot of things. It's a pain in the neck, but it just has to be done. In Virginia, if they're telling you your CSI is this, or you're not selling enough or whatever, use your protections. You have lots of rights. Fight them. If you get a notice, write them back and tell them why they are wrong. Okay? If they are not giving you the vehicles, tell them they're not getting. Make the paper trail for if they are setting you up for something. Set them up on the other end. Okay? Don't ignore any performance threats by them. They're doing it for a reason. Okay, and they're going to tell you, I had one, wasn't selling very well in 2023. They literally said, oh, well, you turned down an allocation in 2018, so we're not going to give you this much allocation now. That was 5 years ago, okay? So fight them back. And that goes with challenging your PMA. If your PMA is wrong, you have the rights to fight it. I mean, there's no time change, it takes a little bit of money. But if they are wrong and you have too big a territory, you have bridges, traffic, people are, opposite way, there's definite reasons why they go hand in hand, right? Performance threats with, challenging PMA a lot of times. So make sure you just know your rights in Virginia. You have the right to challenge it. You're going before a hearing officer, and the commissioner now is really dealer friendly, and we've had really great success with him lately. So you have rights in Virginia. Make sure you're using them. Indemnification, you get sued for something the manufacturer should be protecting you. Make sure you get it off to the manufacturer immediately. You have the right to indemnification. You should not be fighting the case. They should be fighting it for you. And then I'm just kind of going through very quickly on some of these, just kind of a reminder. And then the next one is succession. Make sure you do have a succession plan. Make sure the manufacturer knows it. You have protections in Virginia. Like I said, they can't really say no to family members, but at the same time, make sure that it is set up for that reason. So next is personnel practices. We are speeding through. I apologize. If you have a question, come and find us after. Okay, severance agreements. Basically, the National Labor Relations Board may change again because of the new administration, but basically the next few slides are all on severance agreements, okay? And this has to do with non-competes, dealers basically getting repaid for, you've paid for a tech to go to school and you want the money back should they leave you, things of that, and non-solicitation agreements. Basically, the National Labor Relations Board has basically said all of them are in violation unless narrowly tailored, but they don't basically tell you what narrowly tailored is, okay? So if you have some type of agreement with an employee, it should be very narrowly tailored, and an attorney should really be helping you with that agreement because they have even said that the repayment of costs can prohibit them from leaving the job, okay? So again, what are they paying you back for? Narrowly tailored is exact amount for which you paid them. They did, provide you with a certain number of, a year service or things of that nature. It should be very specific to that person and what you have put into that person and what they are giving back to you because you have put in the same. It's just to make you whole and them whole. Okay, nothing should prevent them from also working. And we're not talking about, we're mostly talking about employees here. Certain managers are exempt from this. But the truth of the matter is, the FTC tried to come out with a non-compete rule. That got knocked down. But the National Labor Relations Board took up what the FTC could not do. Again, that's going to change with Trump. But as of right now, everyone that works on the board, everyone below the heads is still the same people, right? So they are still going to want to make the same decisions that have been made for the last 4 years. So you just got to be really, really careful. A lot of these severance agreements aren't in dealership settings, but some are. So I just mentioned it so because you gotta be careful with what's there. So
This is yet another issue that's sort of been put on hold, but I wanted to raise it because there was a lot of confusion about it when it first came out. Overtime exemptions for administrative, executive, and professional exemptions. The threshold for that salary was going to be raised pretty significantly, and a lot of dealers were a bit confused about the application of this exemption. Remember, as an industry, we have very specific exemptions for salesmen, partsmen, and mechanics, are what they're called in the code. And none of this affected them. Highly compensated employees also increased. That's not generally your folks. Generally, I told most dealers, I'd be surprised if you had that many people in your dealership that would even fall into any of these exemptions. You might. A lot of the administrative folks that you have, if you had them at that threshold amount, you would have to have raised it. But I just wanted to make clear that the exemptions for your sales folks, salesman exemption, that applies for instance, to your service advisors, your mechanics, none of this impacted any of those industry specific exemptions. So I just wanted to make that clear because there was quite a bit of confusion about that when these rules came out. So just understand that those industry specific ones were not impacted by this and are not generally impacted by the broad exemptions that they may be tinkering with. Non-competes. Virginia has a ban on non-competes for certain very low-level employees. This is a move that we're seeing in a lot of states. Virginia was one of them. They literally had a bill in Virginia that talked about you can't tell someone that goes to work for McDonald's that they can't go work for Hardee's. I'm like, do they do that? I couldn't believe that was even happening. So that's basically the level of where the non-competes are in Virginia law. But understand that courts have been very skeptical of these. If your non-compete is basically going to keep somebody from earning a living, you're not going to be able to enforce that. Saying that they can't solicit your customers because you have to safeguard that information, that's different than saying they can't sell cars in Virginia. So just make sure that if you are using them, that you're narrowly tailoring them. And then this is just an issue we bring up because it's something to consider. I don't know that anyone in here that doesn't offer some sort of retirement benefits to their employees. But if you don't, and you've got 25 or more employees, you're required by the state to offer the ability for your employee to take payroll deductions and use this Retire Path VA program. It's not something you can even contribute to. It really is just something you set up with your payroll so that people can save. It's just encouraging employees to save who otherwise are not getting retirement benefits through their workplace. So it may not apply to anyone, but just understand there can be some monetary penalties if you need to register and you haven't. There's a way to go in and file for an exemption to say I have a 401k plan or I have a whatever plan you might have. Be glad to take some. We also obviously are always available. I know looking around the room, there's lots of people I talk to a lot, so I know you know where to find me. I always joke that two things that I love to hear when I get a question from a dealer is, well, I've got a weird one for you. I said, well, I never hear about the car sale on Saturday where they got the car and it was a great deal and everybody loved it and they're high-fiving on the way out the dealership. I only hear about the weird ones, and it's also called job security, so keep the questions coming. It's all good.
Any questions, comments?